thank Professor Rooney and the program committee and Brenda Hollis and Christy there for helping me get to this conference and for inviting me to this conference. I also want to make it understood that I speak in my personal capacity, and whatever I say does not represent the views of anybody I represent or of any of the colleagues that I work with. And I also want to express my humility at being here with many of our distinguished guests who, while I sat in many of the panels or plenary sessions yesterday, saw I have spent an enormous amount of time studying this subject and the details of this subject of criminal justice, particularly the historical aspects. I probably will disappoint you from that perspective because I am a lawyer, and lawyers, in my view, are fairly simple people. We put down what we want to say in black and white. We try to interpret what we have put down in black and white according to the clear meaning of those words, and we try to apply it to concrete situations. So I must admit, yesterday, much of the historical perspective went over my head. It's not that I have not read some of that before, but I'm used to trying to see what principles can be applied to resolve practical problems. I think that's indicated by some of the work I have done, including advising groups like Hezbollah and Hamas and the Taliban, as well as representing, as was stated before, the former Iraqi president. But I also, and most of my time, spend my time representing individuals who have very few other individuals who will represent them. I represent 2.5 million internally displaced people in Khartoum state, and I represent 15,000 Ethiopian refugees who have fled to Sudan, among many other people in similar situations. Those people are as important as, if not more important, than some of the more well-known clients I have. So with that humbling introduction, I want to look a little bit at the Iraqi Special Tribunal, but first put that a little bit in perspective. And to do that, I will paint with a fairly broad brush to take us back to the end of the 19th century, when Gustave Moynier, one of the founders of the International Committee of the Red Cross in 1872, suggested that we create an international criminal court to try to punish individuals who committed atrocities in the Franco-Persian War. That was one of the first instances, not the first instance, but one of the first instances of a proposal of a permanent international court to punish individuals for crimes that have been committed that are viewed as crimes, not by one state, but by many states or by the international community. There were similar movements to try to provide for an international criminal court during the Hague conferences. And interestingly, in both the Hague conferences, and of course Mr. Moynier's expression of a hope for an international tribunal, these were inspired in Europe, and they were opposed by the United States, unfortunately. You're also familiar that after the First World War, we made a very explicit attempt to try to impose justice through an international system of criminal justice in the Versailles Treaty. Articles 227 and 228 provided for the prosecution of individuals who had committed crimes. In fact, they provided for the prosecution explicitly by name of Wilhelm II, who was the Emperor of Germany, for explicitly the crime of aggression, or as it was termed in that instrument, for the supreme offense against international morality and the sanctity of treaties. And in 1938, some of you may know, and I think we look back on that perhaps now unfortunately, very unfortunately after September 11th in this country, an event for which its aftermath I had to attend funerals both in Washington and in New York. having lived for some time in both those cities and knowing people in both cities. But in 1938, India proposed an international criminal court, particularly to try individuals at the already then vague as it is today, for the vague crime of terrorism. Only India signed that instrument. The United States categorically rejected the instrument, and no state, including India, who had proposed and drafted a treaty. It was not merely an idea. It was a proposed treaty presented to a conference of states. No state ratified that treaty. We are celebrating the 60th anniversary of it. These tribunals certainly, as we have heard in the last few days, had a very valuable, or have made a very valuable contribution to the developments of international justice. But I think we should be cautious not to merely congratulate ourselves on this small step, but also, as a few have pointed out in this conference, to be aware of some of the shortcomings of those tribunals. And I'm talking about the Nuremberg and the Tokyo tribunals. I'll just note a few points in relation to these tribunals. First, they occurred after a brutal war, and they were admittedly, by everybody from Justice Rolling, the president of the Tokyo Tribunal, to, as we heard yesterday, the American chief prosecutor and chief justice of the United States, Justice Jackson, they were viewed as victors' justice. As Rawlings perhaps put it, they were victors' justice, but perhaps the best type of victors' justice that could be accomplished at that time. It's also interesting to note, which I noted yesterday, there seemed to be some controversy about, but my understanding of the development of the tribunals, the creation of the tribunals, and particularly the London Conference, was that prior to the London Conference, these tribunals were very much opposed by the United States. In fact, it was France and Russia that wanted these tribunals to be created. And as you may have heard yesterday, if you were here for the talk about Russia's role in the Nuremberg tribunals, Russia took more initiative towards collecting information on war crimes and providing an assembly of evidence that would be valuable in a prosecution than any other state involved in the Nuremberg tribunals. It was only after the involvement of Justice Jackson, and one of the reasons that he has stated multiple times that he was involved is because he thought that the greatest menace of our time must be prohibited and prosecuted. That is the crime of aggression. But it was only after his involvement that Roosevelt and Stimson seemed to compromise on their objections to a tribunal and allowed the Nuremberg Tribunal to be created. It's also noteworthy that even after the tribunal was created, and even or despite the push to ensure that it provided due process that Justice Jackson led very much, the English Bar Council in October 1945 issued a memorandum to its members to warn them not to participate in the proceedings of the tribunal because they believed that they may well be participating in an unfair trial. And those of you who are familiar with the Geneva Conventions know that participation in an unfair trial is a grave breach of those conventions, or in more simple terms, a war crime. Judge Rolling, who I've already mentioned, has also voiced strong criticisms about the trials, essentially pointing out that the Nuremberg tribunals would not meet the minimum standard of fair trial that is provided by the large corpus of human rights instruments, primarily the Fourth Geneva Convention and the International Covenant on Civil and Political Rights, Article 14 and 15 of that instrument. He pointed out that the tribunals violated the majority of the provisions in in those instruments. And more recently, Professor Laila Zanonga has also pointed out that the Nuremberg trials, and this is a quote, became widely criticized for having been unfair. Serious substantive and procedural shortcomings in both sets of trials led many to denounce them as victors' justice. Numerous scholars agreed that both international military tribunals violated the fundamental principles of nollum primus in lege and nolla penus in lege. And he goes on to, in his book, Will the International Criminal Court Be Fair and Impartial?, to indicate a quite large number of deficiencies in both the Nuremberg and Tokyo processes. I think we need to remember these deficiencies in relation to what was accomplished by those tribunals, because that enables us to accomplish something effective and more beneficial than what was done at that time in the future. Indeed, some of this was remembered when we created the ad hoc tribunals, particularly the tribunals for the former Yugoslavia and Rwanda. For example, although those statutes of those two tribunals, which are promulgated by the Security Council, although they limit the jurisdiction of those tribunals geographically and temporally, they provide that anybody can be prosecuted within those geographical and temporal limits. Unfortunately, in practice, despite evidence being given to the prosecutor, now the High Commissioner for Human Rights, Ms. Lewis Arbor, for example, when NATO bombed the Chinese embassy in Belgrade, she concluded that that was not enough evidence that NATO may have committed violations of international humanitarian law. And as you know, the only excuse given by the United States, which admitted its culpability in that bombing, was that they had an old map, which I suggest is not a legal defense to an attack against a civilian site. Between the time of the Nuremberg tribunals and perhaps the cause of some of the developments or corrections that were implemented in the ad hoc tribunals, as I indicated by the comment attributed to Judge Rowling before, numerous international human rights instruments were promulgated. The right to fair trial became an established right of everyone. It became a right that we should provide our friends and that we should provide our enemies. Indeed, as Aristotle once said, that between friends there is no need for justice. There is no need for establishing their basic rights. It is when we deal with our enemies, or our perceived enemies, that we must ensure that we provide them basic rights. Now let me move on, skipping over some of the tribunals like the special court in Sierra Leone, which we have already heard, which I will note, when it came to trying one of the most senior individuals, they decided, or actually the president of the country in which it is situated, decided that that individual should not be tried in that country, but should be sent to an international tribunal composed of international jurists outside the country. But skipping over some of the developments in the meantime, including the International Criminal Court, which we have heard so much about in this conference. In fact, many appear to me skipped from Nuremberg to the International Criminal Court without looking at the developments in between, and which is a different body that is very much in the making right now, a body that will have eventually, hopefully, jurisdiction without any geographical limitations. Let me look look at another one of these ad hoc tribunals that I have a little bit more intimate knowledge about, and that is the Iraqi Special Tribunal, or sometimes known, as it's even been put in some of the laws in Iraq, the Iraqi Higher Tribunal, or the Iraqi High Criminal Tribunal. One thing to note, and I will try to compare in a few minutes, about 5 minutes time, so it'll be very superficial, the differences between where we are now with the Iraqi Special Tribunal and where we were with the Nuremberg Tribunal. Now, they are different entities. The Nuremberg Tribunal was an international tribunal. It was an international tribunal created by the victors to punish the losers. In that way, perhaps there is a similarity, but it was an international tribunal. The Iraqi tribunal, by its very definition, is intended to be a domestic tribunal. One of the reasons that they created the Nuremberg Tribunal as an international tribunal and didn't just try these people in German courts is because German law at the time, as Iraqi law today, provides for sovereign immunity of the highest people in power. But setting that aside, let's look at some other distinctions. Nuremberg and Tokyo were created by victors in a war that had been fought largely in self-defense. We were defending ourselves against attacks by Germany and by its allies, including Japan. It was not the aggressors that created that tribunal. The Iraqi Special Tribunal, whose statute was drafted in English and translated into Arabic, was created by the United States, a country who I share nationality of, a country that is widely perceived, I will say outside the United States and Great Britain, almost unanimously perceived. And I've been to 70 countries since it was created and spoken very often with the heads of state, the ministers of justice, the ministers of foreign affairs, and academics in those countries. Almost unanimously, there is agreement that the United States' aggression against Iraq was illegal, a violation of the UN Charter, a violation of customary international law relating to the use of force. I don't have time today to go into the details of this argument, although with questions I'd be happy to answer them, and I'm sure you can find a voluminous information and arguments on that. But it is important to recognize that the Iraqi Special Tribunal is set up as a consequence of an illegal act. And those of you who are international lawyers will know that under Article 41 of the draft articles on state responsibility, every state in the world has the responsibility not to recognize the consequences of an illegal act. The legitimacy of the Iraqi tribunal, therefore, is a much greater question. I'll try to just wrap up very quickly. The violations of due process in the Iraqi tribunal are much more striking than those before the Nuremberg Tribunal. In part, that is because the Nuremberg Tribunal was operating on a broader concept of justice. It didn't have Article 14 or the almost dozen articles in the Third Geneva Convention that provide specific details about how you provide a fair trial. It didn't have the jurisprudence of almost a dozen institutions, either regional or universally international, that have interpreted the provisions of fair trial. The Iraqi Special Tribunal had the benefit of all of this information, all of these decisions, all of these stated norms. Nevertheless, most of them have been violated. And don't take my word for it. Look at the provisional decision of the Working Group on Arbitrary Detention of the 30th of November 2005, where it found that most of the provisions of Article 14 had been violated. Look at the statements of Leandro Despuy, the expert on fair trial within the United Nations, who has stated that the trial cannot be held, a trial cannot be held fairly before the Iraqi Special Tribunal. I'll just point out that 3 judges have been removed from the tribunal for overtly political reasons. The judges said it, even the Iraqi authorities said it. And 4 of my colleagues have been killed with strong evidence that either the government of Iraq participated in the killing or at least did nothing about it. There's been no investigation in any of these situations. I will just leave you with the thought then that what is happening in this disintegration of international justice is very harmful not merely to the Iraqi people. It certainly sends a very bad message to them about what international justice is and about how justice plays a role in reconciliation. But it has a consequence for you and me. Do you think that a government that is willing to violate the human rights of 52 million people in Afghanistan and in Iraq is not willing to violate the rights of a few million people of its own? I'm confident that this situation can improve, in part because I think at this point, with the establishment of the Iraqi Special Tribunal, the situation cannot get worse. Thank you.
Well, certainly, I'm probably one of the only one of my colleagues who have gone outside the green zone there, and that was at the beginning of the trial, because now it's quite dangerous to do that. And for my Iraqi colleagues, although some, I must admit, live outside of that, I'm talking about either the Iraqi lawyers who now live outside the country and must fly in, myself and my colleagues, when we go into the court. And I've talked with people who support the former president of Iraq, Saddam Hussein, people who violently oppose him. And both categories of people, the one thing they agree on is that this trial is a public show and a farce. Those who oppose the president think that's a good thing because it means he'll get executed more quickly. Those who support him believe that there's nothing they can do about it and it will merely serve as an inspiration to their opposition to the occupation. So certainly these are emotional aspects of understanding what justice is. But I would suggest that the definition of justice provided by Article 14, for example, of the International Covenant of Civil and Political Rights, the definition of justice provided by Article 14 of the International Covenant of Civil and Political Rights, which is ratified by over 150 countries, is a definition of justice that all of us can understand, and that should serve as the basic understanding of justice. If you don't allow, as has happened before the Iraqi tribunal, the defense to see any of the evidence that could be exculpatory, not even to see any of the relevant evidence. As you may know, the first trial, the Doebbler trial, concerns an attempted assassination of the president, a trial or legal proceeding that took place afterwards, which the basis of the accusations are that that was an unfair trial, and these people were summarily executed afterwards. Because it was a fair trial, they were executed in accordance with law, and many countries, including the United States, provide the penalty of execution for treason, which is what they were charged with, essentially. We have never seen the proceedings of that trial. You may have seen that the judge who was on trial, who presided over that trial, said, "Give me the papers from the trial and I'll show you that it was a fair trial." The Americans said to us, interestingly, not the Iraqi tribunal, the tribunal said, "We can't get the papers." The Americans said to us, "We have the papers, but we're not going to give them to you." We never visited the site where they claim these alleged crimes took place. We asked before the trial started. We weren't allowed to visit. And as you know, in that trial, we were given the charges about 30 minutes before, after the prosecution had 8 months to provide their prosecution case. They showed up in court. They said, "Here are the charges." The judge read them out. And they said, "Now start calling your witnesses." That's not appropriate time and facilities to prepare a defense. These are only a few examples. As we provided the court a brief of over 125 pages detailing, and not much law. It was not a memorandum of law. It was more equivalent to a petition in a federal court here, where we just set out in the most basic way the violations of due process. About 40 different violations of due process. And if you count up the possible violations, that's about all there can be in this trial. And I think when you have that degree of unfairness in a trial, you have injustice.
If I may add to that, this idea about who cares whether it's fair or not